Welcome to Fred's Financial Planning Workshops. Today we're covering estate planning and philanthropy. I'm Fred Smith with the Silicon Valley chapter of the AAII. I've given you my email address down here at the bottom if anybody has any questions or comments they'd like to make. And I've also given you the website for our local chapter, which includes the slides and also this video. Before we get into any of the details, we need our standard disclaimer. This is, I think, the ninth of our workshops. We started off talking about investing and then taxes, retirement planning, insurance, covering annuities and long-term care and so on, Social Security and Medicare. Today we're covering estate planning, and next month we wrap up with a case study where we will review all of our previous material. So the agenda for today, we're going to cover the big five in the estate planning documents. And I'm not going to get into too much detail on these because, as I said, I'm not an attorney, and most of the data on this is readily available anyway from a lot of the local attorneys offer workshops, at their offices to cover all of this material. So I'm going to be focusing more on the practical considerations for estate planning. I'll deal a little bit with their digital legacy. I'd like to spend a couple of minutes in California's End of Life Option Act, because that's sort of important and relates to this area, and also on philanthropy. I'll wrap up the workshop with a few slides on what should go into your exit folder. So, reasons why people avoid estate planning. They don't like to think about death. None of us does, but it's a necessary part of living a good life. I don't want to waste or to discuss money with the heirs. That's fairly common. People claim that they're too busy. They come up with all sorts of excuses for avoiding estate planning. One of the ones that may be a little off is where they think the estate is not large enough. And in reality, even younger people, when they're early mid-20s, as soon as they've any estate at all, perhaps a sports car and a student loan debt, that's significant. Even folks like that need to have some form of do some form of estate planning, because if they don't, and anything happens, the estate is going to write a will for them, and it may not be what they want. A lot of folks have not figured out how they want to distribute their assets, or in the case of younger folks with a family, if they have minor children, who they would want to care for those. Sometimes there are family conflicts that they don't want to dredge up. And finally, one of the big issues is that they believe estate planning is complicated and expensive. And they're correct, it is complicated and expensive, but try not doing it, and that's a lot worse. So who needs an estate plan? You need one to designate where your assets are going to go and how they're going to get split up. You need to provide for the management of your affairs if you're incapacitated and not able to take care of these issues yourself. If you have minor children, you want to appoint people to care for them. That also applies for any beneficiaries who may have special needs. I've said here you want to decide whether to probe the estate. In most cases, people figure automatically that they do not want to probate the estate, not want the hassle and expense of doing that. But there are certain circumstances where it may make sense to voluntarily arrange to have your estate probated. We'll discuss that a little bit. Minimizing taxes is always an issue, although not necessarily a major one. And finally, it's an opportunity to have your philanthropic desires documented and taken care of. So how do we identify the key elements? First and foremost is who should handle my finances if I become incapacitated. That includes portfolio management. It also includes the day-to-day writing for bills for your utilities and stuff like that. But if you're unable to do this yourself, you'd like to be able to have somebody that you appoint to take care of those issues. If you become ill and need to go on some form of life support or major hospital care, You want to figure who's going to make the decisions for me in that regard if I'm not able to do so myself. People, one of the elements that folks should think about is organ donation. Then the obvious ones are who should inherit your assets and how should they be split up, who should administer the estate. In other words, who do you want as the executor or trustee, and who should care for any special needs children or minor children. So the first thing you want to do is take inventory. List all of your assets, all of your liabilities. This can be real property and personal property, like jewelry, artwork, or any other valuable objects that you may have. You should collect all your recent financial statements, for all of your checking and brokerage accounts, and note whatever safe deposit boxes you may have. Obviously, you're going to need an estate planning attorney, to write your will or your trust, and to make sure that everything gets documented, according to federal and state law, and that it will be regarded as a valid document. But you may also need other folks to help you with this. If you already have a financial planner, he or she can be a great help in coordinating all of this with other team members. And you may also want a CPA or tax advisor on the team, to help with the tax issues, both for yourself and for the beneficiaries, although the beneficiaries isn't critical. Property ownership. I want to spend a little time talking about the various ways of owning property, because that kind of relates to what we're talking about here. Joint tenancy is one of the things that comes to mind for a lot of folks. Joint tenancy with rights of survivalship. And in that case, there's some constraints. The shares must be equal. Folks tend to think of joint tenancy as just for a husband and wife or two people. It can, in fact, be for more than two people, but the shares must be equally split. Property held in joint tenancy, it cannot be willed, and therefore it bypasses probate. It's not recommended for married couples in all circumstances, or in most circumstances. For any appreciated assets will only the half of the property is going to receive a step up in cost basis on the death of the first spouse. So that's a limitation with joint tenancy. Tenancy in common is another form of holding property. In this case, the shares can be unequal. You can, as many people sharing property in common as you like, and you can split the shares up whatever way you like. It can be distributed by will or trust, and only the interest of the deceased person is going to get a step up on basis. So again, you have that limitation. California is a community of property state, so we want to look at that a little bit. But first, we'll define separate property as anything acquired by either spouse before the marriage, during the marriage as a gift or bequest. If you inherit something during the marriage, that would be separate property if you keep it as such. Or also properties that are acquired after the parties separated, if there's a divorce involved. Community property, on the other hand, is anything acquired during the marriage, usually from earnings or salary. It cannot be disposed of, either sold or gifted by either spouse without the consent of the other. And it's usually split equally between the two spouses unless there's agreement otherwise. And the surviving spouse does get a step up in cost basis to the fair market value on the day of death of the first spouse to die. So we're going to look at what I'd regard as the big five. Well, first of all, you're going to look at what a will is. It's a legal document expressing your wishes regarding the distribution of the property at your death. Who will oversee that distribution? In other words, who will be the executor? And it may care for minor children if you have any. That's one way of taking care of them. Note that the will only becomes effective on death. And for that reason, it cannot provide for your incapacity. So if you're using a will as your primary estate planning tool, you probably also need to include some power of attorney documents to take care of your needs if you become incapacitated and can no longer take care of them yourself. Parties to the will are the testator, the person making the will, the executor who's going to arrange that everything gets distributed properly, and the heirs who inherit the estate, the property. This looks like a nice simple slide with four main forms of bequest, but it actually contains some important information. The one way of passing property onto your heirs is to name it as specific property goes to a specific person. You can say your vacation home goes to your son, and your whatever personal property or your some prized antiques or something may go to a cousin, and you can name the specific property and who it goes to, and that's nice and clean and easy. Same thing goes for a pecuniary bequest. If you can say that you want $50,000 to go to Aunt Jane, and that again is nice and easy. The other form of passing on part of your estate is a fractional share bequest. You might say that 10% of your estate goes to an uncle, and another 20% goes to a cousin, and that's perfectly legal to do. Although we'll see later that it may cause some additional hassles and complications, for your executor or trustee. We'll look at that later. And then finally, it's not uncommon for folks to leave the balance of the estate as a bequest, either to a specific person or perhaps to charity. So you can say that you name all the stuff that goes to all the various people, and then say whatever is left over, the balance of the estate is going to go to somebody else. Those last two items are a little bit tricky to manage, and we'll cover that in more detail. So I'm saying here, wherever there's a will, there's a way to make a mistake. Just be careful. Okay, so we need to talk about probate. Probate is the judicial process of administering the estate of a decedent. Basically what you're doing is having a judge determine the validity of the will, and also the judge will appoint an executor to manage the distribution. Usually the executor that the judge appoints is the person that you've nominated in your will, but it does not have to be the case. If the judge determines that the person that you've named is not competent or will be, for whatever reason, inappropriate to manage the estate, the judge can nominate somebody else. And the executor is usually represented by an estate attorney, just to help you along and keep you from making any major mistakes. The probate estate includes the gross value of all property that you own, except for there are three major exceptions, except for property that passes by contract. And by that I mean anything where you have a document that names a beneficiary, and that's typically life insurance, your retirement accounts, your IRA accounts and stuff like that, and your POD accounts, the pay and death accounts. And all of these, folks normally have a document to sign which says that they can name the beneficiary or beneficiaries of the account after you pass on. Also, as we've already mentioned, property held in joint tenancy does not go through probate. That again passes by contract in this case, to the remaining joint tenants. And finally, property held in a trust will not be probated. It will be passed on outside of probate. So those are the main reasons why folks like to, some of the reasons why folks like to avoid probate. I just want to get back to the word gross up here before we pass on, because that's an important qualifier. If you happen to own, let's just say, a $2 million home, and you've got a mortgage of $1.5 million still outstanding, you might figure you got $500,000 of equity in the home. But when your estate is being totaled up, the liabilities don't count, and so the full $2 million gets added into the value of your estate. Now in California, for small estates, there's a much smaller probate. I've said here you bypass probate. You actually don't bypass. It's just a very minimal, trivial probate, much simpler for estates less than $166,000 and $250. Other states may have the same. I'm not sure. So what are the duties of the executor? Well, first of all, the executor has to file a petition with the court to be appointed as executor and open the probate file. Take an inventory of all the assets. You may have to get an appraisal for some of them. Pay all the bills. File tax returns. Manage the estate assets, including whatever investment portfolio might be around, or if there are any rental properties. All of this needs to be managed. And then finally, after everything is documented and taken care of, the executor will petition the court to allow for the distribution of the assets and file the final tax returns. What I'm showing here are the statutory probate fees by the California probate court, and these are not trivial. Don't forget again, we talked about the gross estate. So if the gross estate is $100,000, it'll be a 4% statutory fee. In other words, $4,000 that will be the statutory fee for the attorney. And usually, if the executor is not an heir, the executor is usually entitled to a fee as well, and it's not unusual for the executor to get the same fee as the attorney, for all the work that goes into doing this. Second $100,000, the fee goes down and down. So if somebody, for example, has a $1 million estate, gross estate, the fee will be $23,000 for the attorney, and a comparable amount possibly for the executor. For higher estates, this gets really high, but you should note though that even for relatively, I won't say modest estates, but certainly in the Bay Area here in California, folks, it's not at all unusual that folks would have gross estates over $1 million. You could be paying $20,000, $30,000, $40,000 very easily in fees. These are fairly high, so it begins to make the fees for a trust look a lot more reasonable. We'll talk about that in a minute. Instead of talking about the pros and cons of probate, most folks think of the disadvantages first, so I'll put it as the cons and pros of probate. Disadvantages are that it's costly, as we've just said. It can be tens of thousands of dollars very easily. It's complex, and there are petitions, accountings to be done, the court hearings that goes on, and it can tie up your life for a significant amount of time. Very often, what it takes, even on a totally optimistic case, it usually takes about 6 months, but it can drag on for many years. And there's a total lack of privacy. Anybody can attend the court, the probate hearings, and anybody can review all of the documents, which is why you very often see articles on the will and the probate issues for some famous folks that are totally public. I've said that there's some possible advantages to probate, and I wanted to point those out. These are very often neglected, but under certain special circumstances, they may be worthwhile. First of all, the creditors must submit all of their claims within a 4-month window. And it's useful in practice to be able to close the window after 4 months and just, close all the books in that regard. Any creditors that drag on beyond that will just get shut out. So it's a clean cutoff point. The other advantage is that the court supervises the distribution of the assets, which means you've always got somebody looking over your shoulder to make sure you're not making any major mistakes. One interesting factor is that if there happens to be a cloud on the title for any property that comes into probate, that gets cleared through probate so that the heir will receive clear title to the property. And finally, even though we know that family is family, disputes can and do occur amongst heirs and even between the heirs and the executor. And the court will be there to arbitrate on those and make those settle a little more easily. Even if you don't write a will for yourself, in other words, if you die intestate, the state's going to write one for you, and it may or may not align with what you would wish yourself. Also, the state will appoint a guardian, and for your minor children, that may not be the person you would pick. The one big thing to note that may be a difference is that the will that the state writes for you will make no allowances whatsoever for anybody other than a spouse and blood relatives. Friends and any charities will get totally written out. It will not be included in a will written by the estate or by the state. In that case, the probate court will appoint an administrator who has the same function as the executor to manage the estate, and also a guardian. In California, the will that the state will write for you says that if you're not married, the estate goes first of all to any children, if any exist, and if not, it goes to the parents, and otherwise it will go to the brothers and sisters, other siblings, and finally to more distant cousins. If the decedent was married or is married at the time of death, the community property goes to the surviving spouse, and separate property gets divided up between the surviving spouse and the children through a non-obvious, somewhat complicated formula I'm not going to get into here. So that's it on wills for now. I'm going to quickly address trusts. And trusts come basically in four different forms. They can be revocable or irrevocable. They can be living or testamentary. The irrevocable trusts are normally used for tax purposes. Whatever you write into those, once it's signed, can't be changed. And the testamentary trusts are trusts that become effective on death. So what we're going to be talking about here when we talk about a trust is basically the more common form, the revocable living trust, and using that in place of a will, and that you can revise at any time, and it becomes effective while you're alive. In fact, that's one of the big things, the big differences with between a trust and a will. The will only becomes effective on death, but so you cannot include any accommodation for incapacity. But with the trust, you can. You can name folks to take over your affairs if you become incapacitated. Also, trusts are a lot more flexible. You can write anything you want into a trust. It's relatively straightforward to get very creative in whatever form you want for how your assets get disposed of and who takes care of what and when. Trusts are particularly useful if they're young children, in that you can name very specific ways in which they'll be cared for afterwards, or if there are children from a previous marriage, that can get a little complicated, and it's easier to handle it cleanly and the way you would like in a trust rather than a will. The parties to the trust are the trustor or the grantor, who's the person creating the trust. Trustee is the person appointed to manage the trust, the equivalent of an executor in the will. And there will also be successor trustees named to take over after the trustee is no longer capable of doing so, either from incapacity or from death. And then finally, the beneficiaries are the equivalent of the heirs. Practical aspects of a trust. First and foremost, trust doesn't mean a whole lot until you transfer all the title for all your major assets into the trust. That will include your home. It will include any other property that you might have. It includes your major brokerage accounts and stuff like that. So the attorney will help transfer these properties into the trust, typically he or she will handle the changing the title on your real estate. It used to be, and I'm not sure if it still is the case, that a lot of title companies, when you were refinancing a mortgage, were uncomfortable dealing with trust. And in the past, it used to be fairly common that they would ask you to remove the property from the trust temporarily, then refinance the mortgage, and then move the property back into the trust. I think most title companies may have moved on from that now, but there may still be some out there that will require you to do that. Usually, any trust will include what's known as a pour-over will, where any assets that did not get transferred in, like we set up, the first item, will automatically be moved over into the trust on your death. That might include, for example, your checking and savings accounts and stuff like that, smaller assets. But you need to be careful. Don't rely on this, because if the assets that get moved over total more than $166,250, at least in California, you will trigger a full-up probate. Probate, a pour-over will is perfectly capable of triggering a conventional probate if you're not careful to move the bulk of your assets into the trust initially yourself. Usually during the trustor's lifetime, he or she acts as your own trustee, and then after your death or incapacity, the successor trustees can and will take over. They can be relatives or friends, or even some financial institution like a bank or otherwise. I wanted to have a quick look at the estate tax rates that are applicable over the years. It started out 20 years ago, a very low number, and it's basically been going up steadily ever since for the exclusion. But in 2017, the Tax Cuts and Jobs Act changed the rules for the exclusion and just about doubled it. So from 2018 onwards, you can exclude just over $11 million from your estate before any estate tax applies. And then that's increased with inflation up to 11.7 million is the current value for this year. And that's for each spouse, so it's twice that for a couple. However, this clause of the Tax Cuts and Jobs Act sunsets at the end of 2025, I believe. So at that point, unless Congress acts in the interim, the exclusion will revert back to the $5 million and change that existed prior to that. And again, remember, this is your gross estate, so it includes it's not just your equity in the estate; it's the gross estate, ignoring any mortgages or anything that may be out there. Okay, so we're going to move on to the third of our big five documents, the durable power of attorney for financial and legal matters. And then what you're doing here is nominating somebody to take care of your affairs if you're unable to do so yourself. And that could be, for normal, paying all your normal day-to-day bills, access your online accounts and take care of stuff there, manage your investments, do whatever rebalancing is needed and so on. And this can be in two forms. It can either be immediate, in which case your agent is authorized to immediately jump in and start helping you, or you can even work together, if you want to on this, but the agent would have the authority to manage your affairs immediately on signing the document. Or the other form that's perhaps more common is the springing power of attorney, which only becomes effective on determination of your incapacity. And that's usually where two doctors will agree that you're incapable of managing your own affairs. So at that point, then the durable power of attorney would kick in. Durable power of attorney terminates on your death. So what would normally happen on your death is that your trustee will take over, on the day of your death, when the durable power of attorney this is no longer effective. It does mean that if you happen to choose the same trustee or the same executor for your will or your trust as your durable power of attorney, it makes the transition a little easier. If there are two different people, that may be, the handoff may be a little tricky. So how should you pick your durable power of attorney agent? Usually it's a relative or a trusted friend, but if nobody comes to mind, you can use a bank or any other financial institution. They are going to usually require that you use their own durable power of attorney form. Even if you have a clause in your trust, they may or may not accept it at its face, the face value. So they may require the use of their own form. The kind of person you're looking for obviously should be trustworthy. You don't want any, you're giving somebody full control over everything you own. So you need to make sure that somebody you trust. They need to be competent and knowledgeable. And even though it's the third bullet on here, it's perhaps one of the most important ones. That is, they need to understand who you are. They need to understand your philosophy, and they need to respect and honor that. This is important, for example, when they're managing your retirement accounts and stuff like that. You want them to manage it in the manner that you would, not in the manner that they would like to. You don't want them getting creative and introducing their own issues and ideas here. So they need to understand who you are and respect your philosophy. You can name more than one agent, but you have to be careful that if there's a difference of opinion, you don't want to get frozen into inaction if they can't agree on what to do. And if you're going to name more than one, it might perhaps make sense to at least stick with an odd number so you can have a majority vote. Having two agents is fine so long as they're both agree on all the major issues. It's just a little warning flag to be careful. You got a similar document that applies for healthcare. In this case, you're authorizing your agent to make major medical decisions for you if you can't do it for yourself, and you're having them, empowering them to discuss the issue with the doctors and work out with them what the optimum treatment plan is. It's preferable to have more than one agent in case for any reason your first agent is either not available or does not want to serve under the durable power of attorney form. And again, it's typically activated when two doctors can agree that you're no longer capable of making these decisions for yourself. And again, like the financial power of attorney, it terminates on your death. I think there's one minor exception to this, and that is that I think the agent may have some decision-making capability in the disposition of your remains after death. I want to talk here a little bit about a living will. A living will, in essence, is a document where you can define what happens to you under certain circumstances. If you're incapable of making decisions, you're giving your agent some notion of what your thinking is on resuscitation, or do you want a DNR attached to your chart? The same thing goes for artificial respiration and feeding, pain relief, etc. Would very often include a paragraph on the donation of organs. Usually, at least in California, the power of attorney for healthcare and the living will are all kind of rolled into one document, into an advanced healthcare directive. And also, we have a POLS, the physician's orders for life-sustaining treatment. This is basically where the physician will complete a form for regarding all of these issues that we talked about up here after discussing it with the patient. And again, it's an agreement that in writing, usually on a pink piece of paper, just to make it stand out, that the physician and all subsequent medical aids are going to follow with regard to what your wishes are. Again, when you're picking your agent for healthcare, the same rules apply. Family and friends kind of come to mind. They should be competent and knowledgeable. You want them to be assertive in that they need to be able to discuss the treatment that you want with the doctor, and frankly, not let the doctor override your wishes. Doctors, absent any other direction, are going to go for all possible means. Usually, they'll go for all possible means, life-sustaining support and so on. And if your wish is to bypass this, your agent needs to be sufficiently assertive to have the doctor comply with your advanced care directive and also with whatever gets written up in the post. But you don't want somebody who's overly controlling either at the other extreme. It should include a HIPAA release so that the doctor and the hospital are authorized to release your medical records to the agent, because without the HIPAA release, their position is going to be, sorry, HIPAA prohibits us from telling you, discussing this information with you. So it should include a HIPAA release. And you should make sure that whatever agent or agents that you nominate to act in your behalf, that they understand your wishes and that they're going to honor them, to respect them. And they should get a copy of the document for their records, because your copy may not be readily available at the time of need. So far, I've discussed, I guess, the first four of the big five documents. I regard a letter of intent not really as a full up. It's the fifth document, but I regard it as a half. So we're really talking about four and a half of the instead of the big five documents. The reason I only credit the letter of intent with a half is that it's not a legal document. It's a document that you can write up. It's probably only a page or two long. It's an informal document, but it spells out all the practical details that may not be in your will or trust. It may go into more detail or beyond what's included there. You should have your access to your computer and electronic data and iPhone and all of that. Make sure that that there's enough information here that your trustee can access all of those. You can spell out what type of funeral you would like. This is a good place to, if you have any specific requests or wishes, to document those. If you've made any pre-arrangements, that should be spelled out here as well. You can even write your own obituary, at least a suggested one, giving the trustee all of the information that's needed to write this for you. And it can include a list of relatives, the contact information for relatives and friends, and who you want to be contacted immediately. So it's not an official document, but it's a very practical help for those who survive you. Typical duties for a trustee are manifold. They go on, and I wanted to spend a few minutes going over the major ones of those. First of all, before your death, when you're picking a trustee, you need to discuss it with the trustee and make sure that that he or she is willing to act on your behalf and accept this responsibility. It's obviously a great honor to be named with this regard, because it's an indication that the person really trusts you and thinks highly of you. But remember, it's hard work, it's time consuming. There's a lot of work to be done, and you need to act responsibly. There may even be some legal liability. I'm not too sure about that, but I don't think it's total. I don't think it's totally free of liability issues, and it may or may not be compensated. If the trustee is also an heir, or a beneficiary, normally you might want to skip the compensation because you're basically moving stuff from one pocket to another. But if the trustee is not an heir, the trust will normally spell out the compensation, a paragraph in there which allows the person to be compensated for all their work. And like I said earlier, this compensation is typically about the same as what the attorney would get. Note that if you accept this, at a later point, you can only resign, after a new trustee is installed. In other words, you have to find a new trustee and get them to take over the case before you resign. You can't just resign. You can't just vacate the chair and leave it empty. So it's not impossible to back out later, but it gets more difficult, and you should consider that before you accept it in the first place. The immediate tasks of the trustee are, first of all, on death, you immediately want to work with the mortuary, you order death certificates. I typically suggest a minimum of 10. They're fairly cheap, and it's a lot easier to order a bunch of them now and have them on your desk for future use. You may only need one or two, because most banks or brokerages will take the original and run a photocopy and return the original to you. But if you're doing this through the mail or something, it's a lot more convenient just to have some extra copies to send out without having to order more. Trustee obviously signs off on all the burial and cremation documents, scattering of your ashes and so on, and then informing the family members, or keeping any family members up to date on what's happening. You need to let the Social Security admin know that the person's deceased, although they usually find out pretty quickly, so that the Social Security account is closed out and Medicare no longer has you on the books. You need to notify the bank and brokerage accounts. And in some cases, certainly in California, they can put a 40-day hold on any activity within those accounts before they get reopened later in the name of the trust. And you need to obviously close out the nursing home account if that's applicable. So there are some things that have to happen within the first 24 hours or day or two, or certainly the first week. First week can be a full-time job. For legal issues, you're going to need to retain an estate attorney. Most convenient would be to use the drafting attorney, the attorney who wrote the trust in the first place, if they're available. But it's not necessary if for any reason you want to pick somebody else. Or if the drafting attorney is out of state and you want to work with somebody local, that's certainly possible. But the advantage of using the drafting attorney is that they're already familiar with the trust, and it's done in their style, and they know their way through it very easily and quickly. We're going to obviously want to coordinate with the attorney on all the issues and provide whatever documentation they need so that you can work together as a team. You need to file a new tax ID for the trust. The old accounts will get closed out and get reopened as under a new tax ID. Very often the estate attorney may do this for you, certainly help you with it. Pardon me. And any documents that you sign, on behalf of the trust, you need to sign them with your name followed by the word trustee. So that, for any legal issues, that you're doing this as the trustee, and anybody has any recourse, it will be against you as trustee, not against you personally. Sometimes if there's a predeceased spouse, he or she may have left initially what was a revocable living trust, and on their death, it turned into an irrevocable trust. And that may be running in parallel with the trust that you're named as trustee for. And if it's a different trustee for that one, you may want to consider combining the two trusts, and the other trustee may well consent to vacating their position, but that it's going to require the other original trustees' consent and also that of the beneficiaries. But it makes it a little bit easier in practice to manage the total disposition. Typical duties, again, financial issues. Collect all of the financial documents which are going to be in file cabinets, file drawers, and boxes under the bed everywhere. And you need to get those to a safe place immediately, especially if the house is empty at this point. Typically, folks transfer all the boxes either to their home or office. And you're going to need to go through all the documents, organize all of the important stuff that need to be kept typically for 3 to 7 years, and then shred all of the unwanted stuff. It's a fairly significant task. For the bank accounts, brokerage accounts, like I said, they may be frozen by the state for 40 days. As soon as that 40 days has elapsed, you're going to want to file an affidavit to open the new accounts with the new tax ID. And at the same time, you have to review all of the bills and pay them in a timely manner, which may mean that you're paying the water bills, the electricity bills, and so on out of your own account if the main account is frozen for 40 days, and then reimburse yourself later. And again, you're going to have to manage the investment portfolio, and the prudent investor rule sort of applies here. Even if you think you can improve on the performance using day trading or something like that, it's not a good idea. The prudent investor rule will apply, and typically you're going to want to manage the portfolio in a prudent manner. You want to make sure all of the utilities that are needed to maintain the property stay in place. To work with the various companies to keep the water and gas and electricity and all of that in place. You want to cancel the non-essential utilities because you don't need to have cable service and something coming anymore. And like I said, you want to pay all of the utility bills, certainly after the new bank accounts are open, but perhaps before with your own account, and then get reimbursed. If there's real estate involved, it can really increase your workload significantly. If the home has to be sold, you need to do it by the book. You interview at least 3 realtors before signing up with any of them. You have to review all of the termite reports and so on. You have to prepare for an open house, and probably retain a staging consultant to do all of this in a professional manner. If the house, if there's a lot of all the normal furniture and knickknacks and all the rest of it around the house that need to be disposed of, you're going to have an estate sale of some sort. And even though the professional estate sale agents get something like a 40% commission on doing this, it's obviously a significant commission, but in my humble opinion, they earn every penny of that because it's a lot of work to do yourself, and it's more time consuming probably than you want to spend on it. The other issue here is that most typical homes, the estate sale is only going to bring in far less money than the original owner might have thought, partly because they're thinking in terms of the original cost and the replacement cost. But an estate sale, it's not unusual for the total household furniture and other assets to bring in only $10,000, $12,000, $15,000. So the 40% commission, it's probably in the region of a few $1,000s. It's not a huge expense. Usually, if you retain professional agents to do the estate sale, you can write into their contract that they have to donate all of the unsold items wherever possible and cart the rest of it to the junk, and that it's their responsibility to have house cleaners in and get the house in clean shape in preparation for close of escrow. Close of escrow itself, you're obviously as trustee going to have to review all of the offers and pick the ones you want, review the preliminary closing documents. But here we're getting back to an issue we discussed at the beginning. If there are any percentage beneficiaries for any of the assets, they need to get a copy of all major transactions, and that certainly includes the closing documents. So you need to get copies of the closing documents to either the percentage beneficiaries or the remainder beneficiaries, and have them sign off that the closing documents are in order and that they accept the offer. That's fine, for local folks who are friendly to the family, but it may be a little problematic for charities, in that, if, for example, the remainder goes to, nothing against the Red Cross, well, let's just say it's the Red Cross, and they happen to have their legal department in Chicago or somewhere out of town, and you're going to have to get their acceptance of the offer before you can proceed any further with it. And it may turn out that the attorney that deals with that is on vacation somewhere. So this whole thing can easily run into many weeks, and you're delaying the probate by this time, or you're delaying the escrow. I'm sorry. The other side of the escrow is going to be anxious to close immediately, and you're saying no, I haven't been able to get an acceptance from some of the beneficiaries yet, so we can't go. So that can be a frustrating exercise. Finally, after you get all the acceptances in place, you obviously meet with the title company and sign all the final closing documents and distribute the assets. Accounting issues, you usually want to retain, well, you don't have to retain an outside firm to work with the estate attorney, but it makes your life a little easier. It's necessary to have the estate valued on the day of death, and you can do this yourself. And for those beneficiaries that have a percentage interest, they're entitled to a full accounting of this, because their first question is, a percentage interest of what? I'm getting 10% of the estate, of the total value of the estate, but what is the total value of the estate? And then you've got a lot more credibility if that is documented on the letterhead of an outside accounting firm, rather than on your say so. And again, you file a report with all of the percentage beneficiaries. Usually you're going to want to distribute as much of the assets as you reasonably can, upfront as quickly as you can. But you probably don't want to go beyond 20 or 30%, or up beyond 70 or 80%. Retain 20 or 30% of the assets still in the trust, in case there's a federal or state audit on the tax returns, or in case of any adverse litigation or anything by any outside parties. So the tax returns can be audited for a period of up to 3 years. So it's usually recommended that you keep at least 20 or 30% of the estate, retain it within the trust for at least 3 years. After the 3-year period is up and you're satisfied that there's going to be no more audit potential, at that point you can distribute all the remaining assets and close out the estate. It's important through all of this to keep meticulous records, because folks can get a little litigious in this, especially if there are relatives or folks involved at a distance, or that have some sort of a grudge or whatever, or feel that they're not being treated fairly. So all meetings, all letters, emails, telephone calls, and so on should be documented meticulously, so that you have a clean record of what happened and when, and basically do it by the books. I've said here that, well, what most attorneys say is that you should keep the estate planning documents forever and the tax returns forever in case of fraud. That may well be the, the cast in concrete option. In practice, I think that 7 years is probably adequate. You're unlikely to to get contacted by the IRS or the state tax authorities after 7 years. It's unlikely that they're going to come up with a fraud case after that time. But typically, most bank statements, brokerage statements, and all of this, you're going to want to keep for up to 7 years. For escrow documents, for both the purchase and the sale, for all property improvements and stock trades, you should keep all of those for at least 3 years. So you're going to have boxes of material that are going to be stashed either in your own home or your office or somewhere convenient for a significant chunk of time. It's not trivial. I've said here you should document everything. I've said a number of times, because very simply, if it isn't written down, it never happened. That's a good rule to live by. You want to communicate the status frequently with the beneficiaries, as a minimum an annual report, but if there are any other major transactions, you need to communicate with them what's going on. And it's the easiest way to keep them on board, because if you ignore them and they start getting a little antsy, it's more trouble for you to take care of it under those conditions. So, it's best to just get your reports out on time and make sure that they're all well informed. Again, as I said, make sure that all major transactions, you get the written approval of the percentage of beneficiaries, but the specific beneficiaries, you don't have a need to know for the estate value. If somebody's getting $50,000, it really doesn't matter whether it's $50,000 from a $100,000 estate or from a $100 million estate. They get the same $50,000. So they're easier to work with. Life in the digital world that plays into all of this. We're all living in a digital world today, and that includes, all the stuff in your desktop computer, your laptop, your smartphone, et cetera, all of your communications, emails, online payments, photo files, on and on and on. You need to make sure that your trustee has access to all of this, not just when you die, but if you become incapacitated. And you need to make it clear what should happen to your brokerage accounts, what should happen to your LinkedIn and Facebook accounts. Does your trustee know how to get into these accounts for you and manage them? Against all security rules, I tend to personally feel that it's not a bad plan to keep a written list of all of your IDs and passwords in clear text. And I've said here, in a safe place. You want to say in a very safe place, known to your agent or trustee, so that they have access to all of this. Or use a reliable password manager. But even if you use a password manager, you still need to let your agent know what the password is to get into that. So you need to manage all of that carefully and make sure that your agent, first of all, make sure that all of the data is secure and kept in a secure place, but at the same time, make sure that it's easily and readily and quickly available to your agent when the time comes. Make sure that the individual is given the authority to play in all of your accounts and manage them, and it's usually best to have this written into the trust. So for a long-term digital strategy might be to organize all your files and back them up. And all of these hard drive and flashcard stuff is probably going out of date. It may be in practice better to put them on a cloud, either Google Drive or Carbide or any of the other cloud storage areas. Make sure the data is protected. Use strong passwords. Keep your list or password manager, in a secure place, and you probably want to include a specific section in your power of attorney paperwork, giving your agent access to all of this. But make sure that they know how to get hold of it. I'm going to spend a few minutes on California's right to die law. Because it's sort of pertinent here. Other states, there are probably half a dozen other states out there that have a similar law. The details may be different, and a lot of other states beyond that are looking into doing it. In California, it was signed into law in 2015 and it became effective in June of 2016. There was a legal challenge filed here because it was passed in special session, but I think that has been cleared at this point. However, there's a sunset clause which officially closes out the law at the end of 2025 unless amended. And I'm not sure if that amendment has taken place yet or not, or what the status is. The practical considerations of the right to die law: the patient must be an adult and a California resident, must have mental capacity to make their own decisions. These are the normal diagnosed with two physicians with a terminal illness, with 6 months or less to live, in other words, probably under hospice care. The patient needs to make a voluntary request to the attending physician, 2 oral requests more than 15 days apart, plus a written request. So it takes a fair amount to trigger it. And this cannot be done by your healthcare under the healthcare directive or a power of attorney. The patient has to do this himself or herself, and must also have the physical capacity to self-administer the drug. Now, what all of this means is that there are 2 important constraints that apply that you need to be aware of. First of all, it's not effective for patients with dementia because they must have the mental capacity to make their own decisions. And it's not effective for comatose patients because they no longer have the physical capacity to self-administer the drug. So you need to keep these in mind because they are important. We're going to move on to a few quick notes on philanthropy for those folks who are philanthropically inclined. Besides sending checks to those charities that fill your mailbox every day. One simple form is to just put a bequest in your will or trust. It may be more practical for some folks to use a donor-advised fund where you make a donation to the fund and get an immediate tax deduction for it. And then you, at a later point, at any point you like after that, you can work with fill out the form or go online with the donor advised fund to make the grant to the charity. The donation and the grant are 2 separate things that can occur at separate times. So it may make it a little easier, for example, at the end of the year or when you're taking your required minimum distribution, perhaps from an IRA, to do that on a time base that suits you to the donor advised fund, and then make the actual grant at a later time. Getting a little more complicated, or in fact a lot more complicated, you have charitable trusts, either a charitable remainder trust or a charitable lead trust, and you really need to work with an attorney on these. And then a private foundation is again a step up in complexity, and again you need to work with an attorney. Pardon me. There are 5 questions I think it's important to ask yourself, regarding any contributions that you want to make to a charitable organization. First of all, how many people benefit and by how much? There's a multiplier that some folks use, that 100x multiplier, that says that you can benefit a lot more people in poor countries or poor circumstances than you can if you're making a contribution to a more well-off organization. For example, you might go out for dinner to a restaurant here and pay, oh, let's just say $50 for your dinner. But for that same $50, you might be able to feed, 100 people, in an African village, where they may not have access to as much food they may in fact be starving. So there's a big multiplier that can be used if you pick the recipients, in the poorer areas. The other thing that you may want to look at is how effective your contribution can be. And one way of measuring this is the quality adjusted life year. It was originally put together as a measure of healthcare benefits, but in fact is applicable outside of that range. One quality is defined as the percentage improvement times the number of years. And just as an example, I've said here, we're shown that if you want to donate a bunch of $4 mosquito nets to an African village, and you argue that that the prevention of or potential prevention of malaria and other diseases might bring a 10% improvement to their life, and that it might last for 5 years. The 10% in 5 years basically gives you half a quality for $4. So you're looking at $8 per quality. If you're contributing in the poorer areas, you can basically buy qualities for $10 or less fairly easily. But if on the other hand you're making contributions to your alma mater or some other foundation or whatever, the qualities can get much more expensive. It's a somewhat soft measurement, and I don't dispute that it's somewhat subjective, but it gives you some means of comparing the benefit and the effectiveness of your contribution. Usually, if you contribute to a well-publicized disaster, it's not as effective as it might do if you're contributing to a more neglected charity. Usually, if there's a hurricane aid or a major earthquake in some area, they get a lot of publicity, and there are a lot of folks that are making donations to that, and you might not get as big a bang for a buck as you might if you made your contribution to a more neglected area. One question you should ask yourself: what would happen if you didn't make your contribution? And again, we're looking at high impact giving opportunities where you can make you yourself can make a measurable difference. And with any of these, you want to put your business hat on a little bit and say, what are the chances of success, or perhaps more importantly, what's the risk that this might fail totally? I'm not saying you shouldn't go for high risk situations, but you need to understand what the probabilities are. And somewhat related to this is the notion that very often staying with your own job full time and earning the dollars to contribute may be a more efficient way of doing this than volunteering your time. Your time might be better off spent earning dollars and contributing that. I've put together a chart here that I find useful. I've not seen it anywhere else, but and again, it's somewhat soft in that it's subjective to some extent on how you read it. But anybody who's familiar with Abraham Maslow and his hierarchy of needs, that's kind of factored in here. On the vertical scale, I've started off with your basic needs, like safety and shelter and clean, food and clean water and so on. We're down here at the lower end. At the upper end, you graduate up through education and healthcare and so on, up to aspirations of helping others and peer esteem and all of that. So this is Maslow's hierarchy of needs going up this way. Along the bottom, I've included a timeline where most of the basic needs are immediate, but some of the other needs at the higher aspirational level are long term. So that gives you a ramp up here. And I've started off with the key point really from Maslow is that any of the needs at any level here really only apply if all the needs below it are already satisfied. So, education, for example, is not going to be at the top of your list until all of these have been satisfied, at least to a rudimentary extent. And we start off, with the safety needs. If you're being chased by a lion in Africa somewhere, that's going to be right at the top of your list, and it's going to be immediate because you're not worried about tomorrow or next week. You're worried about what happens this very minute. I've included also in this, in the U.S., if you have any ghetto areas with gang warfare and stuff like that, if you're at frequent risk of being caught in crossfire for gun battles and stuff like that, the safety can be a very basic need. Shelter, if you think about the homeless in tent camps, that would apply here. Or again, for the homeless folks, they may have a need for food and water, contributions. It could be from a food truck or a soup kitchen, healthcare. And then as you go up the list, you get into education, and I put the environment at the top. Climate control is important. I'm not saying it isn't important, but your dollars may be less of an individual contribution up here than they would down here. So in essence, you get all the cheap qualities down here, and the more expensive qualities are going to be up here. If you make a contribution to your alma mater, it may be well worthwhile, and it may be worth doing. But it's going to be on a more long-term basis and more expensive. So you may want to personalize this chart yourself and draw it up a little differently, but I wanted to give you a structure on which to hang your thoughts. Okay, we're going to finally wrap up here with our exit folder. What should go into that? First of all, you should notice the absolute best gift you could leave for your loved ones is to give them a clean exit folder that in a time of stress makes their life a lot easier. You should collect all the documents needed. Well, I've said here into a large folder or ring book. It's probably multiple ring books or a file drawer or something. Store in a secure place, because this is your whole life in there. You need to keep it safe and secure, but do not put it in a bank deposit box, unless it's jointly owned by your trustee, because otherwise they'll get locked out of it for the first weeks, months, at a time when they desperately need what's in there. The bank, there may be ways for them to work with the bank to get into it, but it's a huge hassle and a big delay. So don't put it in a bank deposit box, either in a file safe at home, or if you do want to use a bank deposit box, then make sure that it's owned jointly with your trustee or trustees. And you want to make sure that your executor or trustees know where to find all of this. There's no point in collecting it all together, but you need to go over it with them and let them know exactly how to access it. The important information that should go in there includes, how to get into your computers, includes the ID and passwords for all of your accounts. You want a contact list for personal, family, friends, neighbors, and all of your professional contacts. You want to have the estate planning documents. What's the location of the original documents? How do they get hold of the original documents? And those are the documents we've discussed it earlier on. If you have a letter of intent or an ethical will, that's useful, as I said, to spell out for your trustee some of the practical issues for you, including funeral wishes or wording for your obituary. Any pre-arrangements that have been done for your funeral should be included here. Financial planning records. It's important for your investment accounts that you include a personal investor profile and a written investment policy statement, because this says how you have been managing your investment portfolio and how you expect your trustee to do so. The cost basis for a non-deductible IRA are actually also for your taxable accounts. This seems like a trivial item here, and up to a few months ago it would have been, but it may no longer be. In 2010, I believe it was, the brokerage firms were mandated to keep a record of your cost basis. But prior to that, there was no such mandate, and the burden was on you. And the reason I say this may become more important is because there's here noises being made that some items may no longer get a step up in cost basis at death, which means that your heirs will inherit or may inherit a portfolio where with your original cost basis. And so if you have any assets that you purchased prior to 2010, it would be very, very useful for them to know what that cost basis is, rather than have to research it themselves afterwards. It'd be easier for you to do the legwork on that and include it in the documents to make their life a little easier. There's no assurance that law will in fact go into place. It may not. In fact, it's unlikely in the present divided Congress that it will pass in that form, but it has been brought up and could do at some subsequent point. And you should include, all the net worth statements and copies of your brokerage accounts and so on. Includes, what credit cards do you have accounts with, and contact information for those. Everything to make it easier for your trustee. Same thing goes for healthcare. Include a copy of all the documents or where the originals are located, including health insurers. You need to have copies of these documents, and again, the location of the originals. Driver's license is one of the important ones, because most mortuaries are going to require a copy of your driver's license before they will take any action. Social Security and Medicare cards. You should copy the ID page of your passport included here, and a copy of your birth certificate. Note where the originals are and how they can access those. Same thing for marriage certificates, divorces. If you have a death certificate for previous spouse, that may be useful to include here, and obviously also military records. You should review your plan on a regular basis. Typically, most folks say that you should revise it or review it and possibly update it every 3 to 5 years. Or if any of these actions occur, you may want to review it. You may trigger a review a lot earlier than 3 to 5 years. Death of a spouse, divorce. If anybody becomes incapacitated, if you move out of state, you may need to rewrite this because the documents may be different. If there's any significant change in your financial situation, or if you purchase or sell a business, all of this could trigger an immediate review. I've included here some reading, mostly from the AAII website, from other sources as well. And I've also included William McCaskill's book, Doing Good Better, which I think is, for anybody that's philanthropically inclined, it's a good starting point to get their charitable thinking in place. I've included websites, and also we end up with our mandatory cartoon here. Raising my allowance is fine, Dad, but I'm really after his power of attorney. Thank you for joining me, folks, on this trip, and hope to see you next month when we do our wrap-up session.